I would now like to proceed to introduce our Chief Justice Dipak Misra of the Supreme Court of India. Good morning, sir. Justice Dipak Misra has truly had an inspiring career. In his early years, he was an advocate in the Orissa High Court as well as the Service Tribunal. He was elevated as an additional judge in the Orissa High Court and then further transferred to the Madhya Pradesh High Court. He went on to serve as Chief Justice of both Patna as well as the Delhi High Courts, and during his tenure as the Chief Justice of the Delhi High Court, he was responsible for helping to clear the backlog of thousands of cases in both the Lok Adalats and the mediation centers. His judgments in the landmark cases of own motion versus the state were responsible for a big change, which led to the FIRs being put up on the internet within 25 hours of them being filed. Sir, it is an absolute honor to have you here, sir, and I would request you now to come up on stage and enlighten us with a few words. Thank you.
Professor Bansal, Dean of Faculty, Professor Ved Kumari, Madam Tikru, the judges of the first session of the Moot Court who are present here, members of the faculty who are here. I will not call ladies and gentlemen, but my friends over here. You see, an old man was asked almost 2000 years back, what's the best experience you have? He said, I would like to be amongst the young men and women so that I can talk to them and they can talk to me. I learn to teach them and they teach me to learn. That is why I am here. One. Second, it's extremely difficult to deny a request from Professor Ved Kumari because we have shared a very, very objective, harmonious relationship, despite few snacks here and there, obviously. I told 4 ladies to go who were going behind to come back because I saw them taking notes, possibly for the Moot Court competition, preparing them. I was reminded few lines from Antony and Cleopatra, Shakespeare, and when, Julius Caesar from Shakespeare, when Antony comes and says on the dead body of Julius Caesar, friends, Romans, countrymen, lend me your ears, lend me your ears. I thought they are not really going to lend me their ears, I am going to sit behind to prepare the Moot Court proposition. So I requested them, but I was told, no, the judges are going to occupy the seats. I must apologize to them, but still, I would like to have their attention. You see, ordinarily I speak extempo because I would like to communicate with the audience. But this time I thought this particular topic requires a different kind of an accent and attention. You really can't try to pep up the students on the disguise that this is a inaugural session. I'll speak about mooting and tell them the man can be destroyed but not defeated, which is a very famous line from Honest Hemingway. But I would like to convey what I really personally believe as a student of law about this amendment. You see, Stuart Chase had once said, violation of some laws in a normal part of the behavior of every citizen, he puts it this way. It's a normal part on the part of a citizen's behavior to violate the law, some normal part. One can put it in a different way. When the social behavior of citizens changes and takes altogether a different pattern, it can be treated as not to be normal and strict laws come into force. Laws are introduced, especially pertaining to criminal activities in the society, regard being had to the experience of the time. When the strict laws are not enforced strictly, they cease to be laws. That is why Edward Begum has proclaimed the laws of a nation form the most instructive portions of its history. Therefore, it is not inappropriate to say that when laws are broken, anarchy comes in. Incidents and events have the potentiality to create the stir in the society to which a legislature in a democracy speedily responds. The social ethos demands a stricter action, and consequences are provided by way of appropriate legislation. Incorporation of Section 326A, 326B, 354D of the IPC, apart from certain other provisions, are the consequences of such stir and torment, and I would add much needed necessity, and was a warrant much prior to its birth. This is because these offences could not be dealt with severity and in a wholesome manner under the erstwhile provisions of the penal law. The provisions are insufficient and inadequate to deal with these offences. The definition of grievous hurt did not include various types of deliberate hurt and were inflicted on important parts of the body, nor did it cover cases of acid attack where multiple grievous hurts occurred. In other words, the definition of grievous hurt was not broad enough to cover the various kinds of injuries which are inflicted because of acid throwing. It did not cover that of administering acid. It gave a wide discretion to the investigating agency as well as to the judiciary. The problem given today relates to both these provisions. I do not intend to express anything on the problem itself, but I am not a judge of the Moot Court today. Section 326A deals with voluntarily causing grievous hurt by use of acid, and Section 326B deals with voluntarily throwing or attempting to throw acid. I restrict myself to the anatomy of Section 326A alone. The said provision stipulates that whoever causes permanent or partial damage or deformity to or burns or maims or so on and so forth, which the section says are punishable by 10 years minimum, can go up to life. The two provisions that the fine amount shall be commensurate with the medical expenses and it shall be paid to the victim. Regarding to the opposite of provision, I personally feel it makes it graphically clear that the legislature has covered all the aspects, the act, the consequence, the repercussion, and the consequent punishment. The concept of reasonableness of fine has also been made commensurate with the expenditure made for the treatment of the victim. The doctrine of victimology, which has been gaining ground throughout the world for last decade, has really been accentuated in this provision. Acid throwing had become paramount, had become rampant in our country. You see, while I was a judge in Madhya Pradesh, I got a telephone call from my previous stenographer. So a tragedy has occurred. I said, what? My daughter, who was studying in second year commerce, was traveling in a rickshaw. The boy was following him constantly. She showed disinterest. She told him no, and the result was, while she was coming alone, acid was thrown. Fortunately, on half the face, half the part of the one side of the face is gone, and they said there has to be a plastic surgery. 3 plastic surgeries and can be cured. Look at the agony of the girl whom I knew. Of course, I could say you can come to they will put together, there is a plastic surgeon there. He said, no, somebody is working over there. And whatever the punishment, forget it. And look at what did this do? Doesn't she have a right to say no? She did have. But unfortunately, the boy did not realize it. One has noticed that throwing of acid sometimes remain in the sphere of threat. If you don't agree, I'll throw. Threat. And sometimes it has transformed into action. It has been mostly attempted on young girls and women. It has also seen that it deliberately thrown on the face of the obvious, for the obvious reason, that is to destroy the personality of the victim, because face is the grace of a man or a woman. Human civilization treats the face of a being as the fundamental presentation of beauty, and therefore the criminals with forward mind target the face to deform the beauty. Once the young person's face is deformed, a fear reigns both within and without. Possibly, for that reason, it has been said, beauty is eternity at itself, gazing itself at a mirror. Beauty is eternity, gazing itself in a mirror. Victim of acid throwing gets mortally scared to see herself in the mirror. Socially viewed, it is a brutal act to corrode the respect for women and creates an erosion in a civilized society. The dreams and aspirations of a young girl gets atrophied. It's a matter of great shame and grave concern for the society. It's a cruel humiliation of life. That is why the legislature has commanded that the offence, when proven, the minimum sentence shall not be less than 10 years and may extend to imprisonment for life and fine. By providing imposition of minimum sentence, the legislature has kept in view the object behind the criminal law is to maintain law, public order, stability, as well as public peace and progress in a country and society. Fieldman, in his law changing the society, stated, state of a criminal law continues to be, and it should be, a decisive reflection of social consciousness of society. Therefore, in operating the sentencing system, law should adopt the corrective machinery or deterrence based on the factual matrix, and it has been so described in this provision, and it is the duty of the investigating agency, the public prosecutor, and the judiciary to see that the law is respected and implemented in their respective spheres. It can be stated with certitude that the mental torture a woman suffers because of such horrendous attack on her is not less than an attack on her physical frame by way of rape. It's obligatory to remember the reputation of a woman in a society shows the basic civility of a civilized society. No member of society can afford to conceive the idea that he can create a hollow in the honor of a woman. Such thinking is not only lamentable but also deplorable. It would not be an exaggeration to say that the thought of sullying the physical frame of a woman in the demolition of the accepted civilized norm, physical morality. All of you know about morality, but there is a concept called physical morality. When you try to attack a woman, any person, anyone attacks a woman in this way, he is trying to destroy the physical morality of the person as well as that of the society. In such, my personal view, which is a part of the judgment, in such a sphere, impetuosity has no room. The youthful excitement has no place frustration has no entry. It should be paramount in everyone's mind that on one hand, the society as a whole cannot preach from the pulpit about socio-economic and political equality of the sexes, and on the other, some forward members of the same society dehumanize the woman by attacking her body. You see, recently in Swaminarayan, the Supreme Court has commented that nobody can be deprived of the dreams of life, particularly it is an assault on the individuality and inherent dignity of a woman with the mindset that she should be elegantly servile to men. I am not talking about male chauvinism, which the ladies very frequently use. I am saying elegantly servile to men. It is a crime against the holy body of a woman and the soul of the society, and deprives a young Colin of the dreams of spring of life, who and might be psychologically compelled to remain in the torment of winter. Some of acid throwing has been regulated in a recent judgment in Lakshmi case. I need not say that, you see, when there is to be rejection, no, this is not a part of the speech, reminder of I'm telling you. In 200 years back, a poet wrote, she was rejected by a lady. Two lines are very important. I'm not saying you to follow it. Somebody asked Mr. So-and-so, how do you react? He spoke two lines. One, henceforth I shall not be friendly with roses. Henceforth I shall not be friendly with roses. Eloquently spoken. And second line is really very difficult to understand. You should understand, William, I feel unrequited love is the best love. May I explain or you understand? I do not understand. Explain. Okay, there's a command to explain. Unrequited love is the best love. X loves Y. Y doesn't know. Y doesn't respond. Yet it's called unrequited, unresponded, unaccepted. But still, that's the best love, because that love remains constant, consistent, and impregnable in the memory of the person. Look at the beauty of the idea. And today, it's just reverse. You can't accept somebody's disinterest, non-acceptance. One should accept with honor. That we are missing. And this is slightly beside the track. Coming to section 354D, it's perceptible that the said provision is definitive, certain, and eloquently clear. The said provision has to be interpreted on the bedrock of accepted jurisprudential concept of our criminal law, because the language employed is absolutely unequivocal. One is required to understand the text and the context and the logical meaning attributable to every word. Section 354D consists of two parts. However, for application of both parts, the perpetrator must be a man and the victim must be a woman. Then I have tried to define and describe what it exactly means. I need not read out, which that may be helpful to you in your Moot Court problem. But the effect thereof, the stalking, can be terrifying and results in embarrassment, shame, frustration, irritability, fear, and anxiety. In rare cases, it can result in extreme anger, phobia, panic attacks. In most cases, victims are at a loss about what they should do in such circumstances. In Indian context, embarrassment, and inability to talk to elders, including parents and male members of the family, results in victim suffering frustrating adverse emotional consequences. There is a fear in the mind of the victim that they would not be allowed to go out of home or move around from friends. It invades one's right of privacy and choice. It imposes confinement and denies liberty to walk, talk, and move around freely without any hindrance or cause to worry. Such a fear, I would say, a negation of life, capital L-I-F-E, as broadly understood within the draft of Article 21 of the Constitution. You see, now I've discussed about the cyber part in the sense that can be really entrenching and encroaching upon someone's life, liberty, privacy, and creating a fear. You see, what is the most disturbing part in a man's life, Fear. Now, slight digression. What did Mahatma Gandhi do? I am not asking a question to the young judges of law. I don't know if the professors have analyzed it or not. Indians were suffering from a mindset of fear. And Gandhiji, which he learned the lesson in South Africa, propagated in India, that get out of fear, ostracize fear, excommunicate fear, do not be afraid. And once fear is gone, India was a nation of strong people without arms and weapons. And you can't fight with fear. Can't fight with a man who is fearless. Why, He gathers courage. And courage is the mother of all virtues. And that is why how could English fight against people who are fearless even to die. That's what I am trying to emphasize on this. The core point behind stalking is harassment of the victim, and it can be physical and mental and corrode herself. I have not read the whole thing. I have requested Vedkumariji to put it in the website. Well, I am absolutely conscious we are behind the time, but still I will make it. In my humble way, I have made an endeavor to understand the provisions, because I still consider, and all should consider, we are students of law. Some lady lawyers are sitting, of course I don't recognize them when I see without robes, but still, every day we put question to elicit an answer. It's not with a saying that we know the law and you don't. Only purpose is to understand, appreciate. I tried my endeavor, I have efforted, meaning how it has come into existence, what would the meaning. However, I must add with emphasis that younger generation has to understand the impact and effect of the law, as well as the social responsibility to be guided by civilized norms. I must state with uninhibited and unreserved delight that the Law Center, Faculty of Law, Delhi University, has floated an excellent idea by putting forth a problem of this arena for a moot court competition. I am sure the participants, while putting forth their respective cases, shall keep in mind the legal framework, the concept of ratiocination, syllogistic analysis, and requisite sensitivity. I am absolutely certain that the participants will go satisfied despite whoever may be the final winner. And you know why? This is not for the first two benches. You know why? According to me, life is not a noun. Life is a verb. You agree with me, man? Thank you. Life is a verb. It kicks one to live and fight. Life kicks one to live and fight. Participation in a moot court competition is an intellectually sharpened and eloquent fight without any animosity. Thank you very much.